Hey guys, Alex Roubian, New Jersey Second Amendment Society. We're here today with our attorney, Albert Rescinio. There's been some developments in the federal lawsuit challenging New Jersey's red flag law, and we want to give everybody an update. Albert, the camera's all yours.
Thank you. Recently, on Friday afternoon, Judge Martinotti from the Federal District Court rendered a decision on the motion which we had filed requesting a preliminary injunction on the red flag law for the entire state of New Jersey. First thing you have to understand is preliminary injunctions are an extreme remedy. They're very rarely given, and you have to meet a very stringent set of facts. The decision encompassed far more than the preliminary injunction, though. But the judge denied our request for a preliminary injunction, and he denied it based on an analysis of just one prong. He said that Mr. Greco had not met the standard for irreparable injury. That means an injury which, unless the preliminary injunction is given, cannot be fixed or made whole. So basically, in my opinion, at this juncture, what the court has maybe said, maybe inadvertently said, is that you're not going to get a preliminary injunction on this law because if you have not been injured by it, you don't have standing, you can't bring a suit. And if you have been injured by it and they've taken your weapons, well, they've already taken your weapons, so giving you a preliminary injunction at this stage is not going to prevent any irreparable injury. It's a circular logic, but
I was just going to say it sounds like a very circular logic.
It is, but the analysis of the court may change if some of the facts changed for somebody else. So I'm not saying that that's absolutely the court's final definitive say on that. However, in winning a battle, they've really pretty much, at this point, in my opinion, the state lost the war. We had filed a motion for class certification, class action certification. And the state had objected to that, saying that the court had not yet decided the issue of standing. The court thereafter dismissed the motion without prejudice, said refile it, and asked all the parties to brief the issue of Mr. Greco's right to bring this lawsuit. That's called standing, Article 3 standing. In the decision, Judge Martinotti has specifically said that Mr. Greco has standing under the First Amendment for his violation of his constitutional rights of free speech, the Second Amendment, which is, as we all know, for firearms, the Fourth Amendment, which is the illegal search and seizure, and the 14th Amendment, which applies the Constitution to the state courts. Conjunctively, while he didn't specify it, it would also therefore be a finding that the state court constitution, those provisions which are similar, have also been violated. While it wasn't argued at the preliminary injunction, the Fifth and Sixth Amendments of the Constitution, we believe, will also be found that Mr. Greco, for the same reasons, has standing, and that's your right to be advised, your right to be represented, your right to confront witnesses, none of which Mr. Greco or anybody in the ERPO Act has been given prior to, in New Jersey, the issuance of a TURPO. So we are in extremely good shape. The judge also said, specifically in that order, that Mr. Greco has shown a reasonable probability of success on the merits as the statute clearly violates the Fourth Amendment of the United States Constitution. That now decision is binding on every judge in the state. It's called collateral estoppel. So we have just struck a huge blow throughout the state that affects every TURPO and ERPO that's going forward, and everyone that's pending and everyone that will go forward. No longer can they stand in court, the state, and say that they are here under this constitutional law. The law has been found to be violative of the Fourth Amendment. Ultimately, we will prevail on the case. In prevailing, there may be in the future a preliminary injunction, a permanent injunction, which is a different standard than the preliminary injunction. Also, we have just refiled the motion for class action certification, requesting that the court certify the class of every individual who has been subjected to a TURPO in the state of New Jersey. Last count, that was 215 people in about the first 140 days. Is how many times the ERPO Act was used, and granted, because if somebody applied for a TURPO and they didn't get it, one, the person might never even know because you didn't receive notice anyway. But if they didn't get it, then there was no harm to ultimately no real harm to anybody's constitutional rights. But for the 215 people as of the first 140 days, they would be included in that class. And we are proceeding forward, proverbially all guns blazing, for all of our gun people out there, seeking to protect not just Mr. Greco's rights, but everyone else's constitutional rights in the state of New Jersey relative to this law, the application of the law. By way of note, the court also said that the administrative memos which were put out there are not satisfactory fixes to the violation of the Fourth Amendment because they are not permanent fixes. They can be changed at any time. There's some issues regarding that and regarding how the law is still being applied. It's our opinion, and we're still fighting the issue, that the mere application of the law without it being changed can't be fixed by a memo, because our reading and understanding of the law is if a judge finds good cause, he has to issue the TURPO, and under the law, the search warrant automatically issues immediately. It's not discretionary. The fact that a judge under one of these memos later on says, all right, now I'm going to go back and I'm going to re-examine this search warrant under probable cause is irrelevant. The damage is already done. The search warrant is already issued, and nothing in the law, in the statute, gives the judge the right to go back and re-examine it, to reissue it, to not issue it, or to withdraw it. So the search warrant that was issued on good cause has to be issued, regardless of what the judge says regarding any subsequent analysis of probable cause. So we still have that issue, and that's still an issue that's being fought, and that still is going forward.
Okay, very interesting. You basically I had a lot of questions, but you already answered everything. So, the main point I was going to make was, the judge denied the preliminary injunction, but also stated many issues were violations of his rights of the plaintiff. Well,
specifically said that Mr. Greco has proved standing, which means he had the right to file the suit and he has the right to proceed. Just as not receiving a preliminary injunction does not mean you're going to lose the case, not by any stretch of the means. Having a judge say that he's found standing does not mean that you're necessarily going to automatically win, but it does mean that you're in the ballgame.
Okay.
But the judge saying that the law is clearly violative of the Fourth Amendment is an absolute victory for Mr. Greco and everybody else in this state. And his wording that he said, Mr. Greco has shown a reasonable probability or a probability of likelihood of success on the merits, strongly indicates to everyone out there that Mr. Greco will win and is in the right.
Okay. So, metaphorically speaking, it's a small loss of, the battle has been lost, but the war can be won.
Oh, absolutely. Okay. And in fact, the war is being won. Mm-hmm. The decision, while as to the preliminary injunction, is not unexpected, and was in the, I'll put quote, quote, state's favor. The balance of the decision is really in Mr. Greco's favor. And it was because the judge ruled on the issue of standing, gave us the right to immediately refile the motion for class action certification, and has now given us the roadmap for the things that we're going to do. The next thing that happens now, according to the judge's order, is the state has to file an answer. As soon as they file an answer, we're ready to move with our next phase of the litigation. We already know what we're going to do. We're already primed to do it. We're already preparing for it. So we are in good shape.
Okay. There's been a lot of confusion based on the acronyms that are being used. A lot of people commented in our last video about what an ERPO is, what a TURPO is. Can you just give a quick summary of the differences?
Sure.
And what they are?
The ERPO is the Extreme Risk Protective Order Act. That's the act which was passed about now, I'm going to say close to 2 years ago, but it went into effect on September 1st, 2019. Within the ERPO Act, that's the Extreme Risk Protective Order Act, there's a thing called a TURPO. That's where it starts. It's the Temporary Extreme Risk Protective Order. That's the first thing they go for. Then, if they get the TURPO, you come back to the Superior Court to argue whether or not a FERPO should be issued. That's the final extreme risk protective order.
Okay.
Consider it like a temporary and a final restraining order. And then the standards that had to be met at the TURPO level are different from the standards that have to be met for the FERPO. Supposedly, they're higher standards. How it's being administered in practice remains to be seen. Mr. Greco's case has been stayed. There's an argument going on right now in the underlying Superior Court case, which we're following up on. And there's, discovery issues. But for everybody to understand, the ERPO is the act. That's the Extreme Risk Protective Order Act. There's the temporary Extreme Risk Protective Order, and then the final Extreme Risk Protective Order.
And once the TURPO, the temporary, is issued, they, by law, statutorily have to have a hearing within 10 days.
Well, the law says that they're supposed to have a hearing within 10 days for the FERPO.
For the FERPO, yes.
My position, and I've used it with Mr. Greco, and I know other attorneys have probably used it, is that is really and should be at the discretion of what they call the respondent. Euphemistically, realistically, the defendant. But because it's couched as a civil statute and not a criminal statute, although it's contained within the criminal code section, they call you a respondent and not a defendant. But if the respondent is willing to hold off on the FERPO hearing, there's no reason the court shouldn't hold off on it, because the respondent should have every opportunity to be prepared for his case. I know in our case, the state, I have no other way to say it, played games with discovery. The only way I can describe it is in a criminal action. When you go into criminal action, they have to give you all the discovery. They have to give you all the police reports. They have to give you all the videos. They have to give it to you all up front. Well, when we went, at first there wasn't any discovery. Then they gave us some paperwork. They never told us there were any videos. When I first met with my client, was prescient enough to say to my client, go get the transcript from your September 6th TURPO hearing. He went, got the transcript. I read the transcript. One of the first things in the transcript was the judge talking about watching a video and the state saying, oh, no, Judge, we're not going to watch the video. We're going to give you live testimony, which immediately raised two concerns for me. One, there's video and you didn't tell me, which is a big no-no. I want the video. Two, why wouldn't you show the judge the video of the actual interview with Mr. Greco? Why would you put on live testimony and not show it? What's in the video you don't want the judge to see?
Probably the video doesn't have anything incriminating in it, and if anything, it works in Mr. Greco's case.
Well, in our opinion, that's exactly accurate, and that will remain to be seen and developed in both the federal case and the underlying Superior Court case. Then, of course, we found out that there were other reports out there. We weren't given reports from other agencies. We've been writing letters and chasing it. We still don't know if we have everything. And now I'm at the point where, I want to depose people. I want to depose some of the police officers from the township, in particular the sergeant who testified at the TURPO hearing. I want to depose the agent who was at my client's house and interviewed him and testified at the TURPO hearing. I want to get these people in a room with a court reporter and be able to show them stuff and ask them very pointed questions before I ever call them back onto the stand. Because I intend for them to come in and testify.
But why is this is kind of this is really infuriating, because they have these rules and we're supposed to provide all the evidence, the discovery, to the defendant, Mr. Greco, and you as the attorney, and they're playing these games, and they're not providing you all the information, and they're lying to you, and they're lying to the court. Why is there no punishment for them, kind of, I guess, misbehaving and not following the rules and not obeying by the law?
The first thing is I don't know how much the court knows at this point. Certainly, we've brought some of it to the court's attention, but the court hasn't seen and known it all. The other thing is realistically, and I hate to say this, but I don't think the court's going to do anything to the prosecutor or the prosecution. There's other issues going on.
But if you did that,
if I did that, or if a defense attorney did that, we would be skewered.
You'd be
from
in
the
jail.
bottom
I'd be bailing you out.
Right. They'd put a pike right from the bottom through the top of our heads.
Yeah.
But they're not going to do that to the prosecutor. They're not going to do that to them. But there's other significant issues also which are going on within the Greco case on motions which I filed in the Superior Court, which I have just written to the Superior Court telling the judge, before this can go forward, besides the fact that it's our position, it still needs to be stayed because the federal case is still pending, and that's what I asked the state case to be stayed on, not the preliminary injunction, but the final outcome. There are issues between the state case and the federal case that I filed motions in the Superior Court saying to the court, we have to have hearings on this. We have to have a probable cause hearing, which in a criminal case, a judge who issues a search warrant can't hear the probable cause hearing of the search warrant that he issued. Otherwise, I mean, you could understand. Oh, I issued this search warrant? Yeah, I think there was I find there was probable cause for me to issue the search warrant. I mean, you don't do that. That has to go to a new judge for a new judge to make an independent determination as to whether or not probable cause was met and the search warrant should have been issued. So that's one of my motions. Now, again, as the court noted in the Superior Court, as the judge noted, these are novel issues because it's not a criminal case. Nobody's ever done the stuff I'm doing before. I'm blazing the path. I'm literally hacking through the jungle with a machete, blazing a path for everybody else to follow here. So there's an issue there's a different issue. There's another issue about dissemination of information. The information on the Superior Court level is privileged to the respondent. Nobody is supposed to have access to that except the respondent's attorney, the prosecutor, and the judge, without the respondent's consent. It's his privilege. But there seems to have been some dissemination of privileged information, which we're not letting go of at this point.
Okay.
Because we're protecting my client's rights to the fullest.
All right. Guys, that's an update on everything going on. We need your support. NJ2AS.org. Become a member. Join. Make a donation, whatever the case is. We need your help and support to help fight this back. This is obviously going to be going on for much longer. Albert, people have been asking me about you, who you are, what kind of law you practice, and I guess give us a little background about yourself as a personal attorney.
I have a very general and broad practice. I have been practicing for 30 years. I have an accounting background. I was originally a tax attorney. I do tax work. I do all sorts of commercial transactions, real estate, commercial real estate. I do wills, trust, and estate work. I do all types of litigation, as you can tell from this. I do criminal. I do civil, personal injury, workers' comp, municipal court, DWI. I do just such a broad range of things. I do matrimonial work. I do post-judgment matrimonial work. I handle restraining orders. I testified in court on behalf of a juvenile today on a special needs trust, which was a first-party self-funded special needs trust of a little boy that was who's disabled, and they needed a special trust to be created, which I was brought in to consult on. So I do a very broad range of different services for my clients. Many of my clients use me for multiple things, and I receive a lot of referrals from other attorneys and organizations because of my skill set.
Excellent. So Like this video, guys, because all the social media platforms love to demonetize us or shadow ban us. So like the video, make sure you share it with friends and family and all your friends on social media. Make sure you repost it, whatever it is, to try to get it out there. Because unfortunately, as a Second Amendment organization, we're being heavily discriminated against on social media platforms. You know, just Google shadow banning and so forth, and it talks about how these tech companies are trying to suppress our voice, which is suppressing your voice because we cannot get our information out. So stay tuned, NJ2AS.org. We need your support. We need to support Albert on this case because it could literally any day we get people telling us every day about how just a false accusation had them get a red flag against them, their guns were taken away, and now they have to fight back to get their rights restored. And it's a massive violation of our constitutional rights. It's just scary to think that we can say that we're actually part of America, because this is just a modern day witch hunt where you can just accuse your neighbor of being a witch and their property is being taken away. And in today's day and age, anybody can accuse you of something and your guns are being taken away and you have to prove your innocence. That is the most un-American thing you can possibly imagine. Once again, NJ2AS, I'm Alexander Roubian.
I'm Albert Rescinio. Thank you.
Thanks and have a great day.